Greetings, distinguished guests, ladies and gentlemen. My name is Stephen Thiru, and I'm the Vice President of the Commonwealth Lawyers Association, Australasia, as well as Vice President of Law Asia. I'm pleased to moderate this webinar today. May I start on behalf of the four organizations that are presenting this event to welcome you to this webinar, which is entitled Loss of Majority in Parliament and Forming a New Government, the Guiding Constitutional Principles and Conventions. This is the second webinar in our series of 4 webinars under our Constitutional and Rule of Law series of webinars. A bit on this webinar. This webinar brings to sharp focus the loss of mandate in Parliament by a popularly elected government and the process by which a new government is formed. We have increasingly witnessed the change of governments in recent times, and certainly since the declaration of the COVID-19 pandemic. Our distinguished speakers will deal with the applicable principles and conventions that govern the legal legitimacy of the new government, particularly when there are no fresh elections midterm to return the mandate to the electorate. There is widespread concern that these new governments in various jurisdictions may have subverted the rule of law to preserve their seats of power and have refused to submit themselves to a fresh mandate. The perspectives and tensions that are caused by this constitutional upheaval of loss of confidence in Parliament will be explored by the panelists, and they bring to this discourse a wealth of knowledge and experience from their diverse jurisdictions, that they represent. At the end of the presentation, there'll be a time for questions to be posed to them on their presentations and on any other related matter that you wish to raise on the topic of the webinar. For your information, we have 378 registrants for this webinar, and they represent 50 jurisdictions. And we can therefore look forward to a good exchange of views throughout this webinar. With that, I wish to now introduce our first speaker. And our first speaker is Dr. Wolfgang Barbek. Dr. Barbek is the Vice Chair of the International Law Section of the Law Council of Australia. He has been providing advice to governments on constitutional reforms for more than 20 years. He twice chaired the Constitutional Conference for the State Constitutional Commission of Georgia during its constitutional reforms in 2010 and 2017. His publications include Rewriting Constitutions, and he's currently working on a 3-volume comparative constitutional manual on how to change constitutions. Professor Barbek is also a commercial solicitor with Hall & Wilcox in Sydney and the honorary adjunct professor at Bonn University. Wolfgang, up to you now.
Stephen, thank you very much for your kind introduction. I'm very excited to be here and to participate to this seminar. I thought I am going to share my screen with you. Let me do this now. Here we go. So I have been thinking to give you a bit of an introduction and hopefully being able to combine some of the civil law constitutional approaches and the common law approaches. As you know, many countries in the South Pacific are governed by common law tradition, but the civil law tradition is, of course, the predominant one in the world. And I think it's good to borrow from both histories and experiences to to benefit from a good outcome. So why am I speaking to you? As Stephen has kindly mentioned, I have been honored to chair some constitutional conferences in the past. And what I noticed when doing that is that every country is basically starting afresh. Yeah, it is when it wants to amend its constitution, it is basically puzzled of the many, many solutions which there are. And therefore I thought, oh, wouldn't it be good to have a book or some books where the best practice of constitution making is laid out so that lawmakers can dwell on previous experience or experience around the world to identify what is the best solution for their country with their own history, of course. So when I looked at that, the idea was to break constitutions into components and to compare them internationally. So not necessarily look at all of the countries, but look at all of the mechanisms or instruments which are available. And as you may know, a lot of the constitutions have very similar instruments, so I think it's a fair course to compare them. I have teamed up with a professor from Germany, Albrecht Weber, and a lot of other supporters. Luckily, some of them are on this webinar as well. So I'm very grateful to have received lots of assistance in that. And the book is called Writing Constitutions, and it comes in 3 editions, in 3 volumes. One is looking basically at the governance mechanism like we will do today. The second one that we're currently working on is, so the first one is with the publisher. Second one is on fundamental rights, allowing you to basically draft a catalogue of human rights. And the third one is on constitutional principles like elections or justice principles and other things. So I wanted to give you a little overview on the loss of majority. So there are different players involved in this scenario. The first one is, of course, and it springs to mind, is the opposition. So the opposition, what is the instrument that the opposition usually has? That is the vote of non-confidence. And we'll come to that in detail in a moment. However, there are other instruments. For example, the government. So what can the government do? The government can, for example, resign. And then it's over to the head of state or the president, who plays then an important role. One of the most important functions of a president is the mediation, arbitrary function. And you may have seen this in Austria with Mr. Van Bellen, or lately with Sergio Mattarella in Italy, who played this masterly with Matteo Salvini and Matteo Renzi, who both wanted to be appointed perhaps, but then didn't get the go. The government, of course, might want to try a vote of confidence beforehand, and some of the constitutions, like the South African or Nepalese constitution, have both mechanisms. So this is certainly very different from the vote of non-confidence. The third element is the head of state, him or herself, and it can remove the government. So that's quite obvious in a presidential system where the president is the head of the government and can just remove the government. But there's also a crisis competencies if there is a deadlock in a parliamentary system. And we in Australia had this experience 50 years ago. It's still very controversially debated with Gough Whitlam, or Nepal had this in 2013. And maybe we hear a little bit later from Saroj, our colleague here, on this one. Nepal is a very interesting country constitutionally. I'm quite excited to hear more about that. Last but not least, we have Parliament. And Parliament, of course, can in some constitution allow for a self-dissolution. Now, all of these instruments then lead to a formation of a new government, be it by appointment from the head of state, be it by the election through the vote of non-confidence, or through new elections. I would like to focus today on the vote of non-confidence. And as we will see later on, all of these 3 mechanisms can also occur after a vote of non-confidence. In particular, I would like to point you to the constructive vote of non-confidence. The guiding questions for drafting a non-confidence clause, and I would really encourage you also always to look at amending a constitution if there's a possibility, because constitutional conventions are, of course, great. Legal guidance by the judiciary is great, but if you can vest something in the constitution which cannot be repealed by the next government, that's even better. So the guiding questions are: who has the right to initiate a vote of non-confidence? Is it, what sort of majority do I need to initiate that? Who is subject of the vote? Is it the Prime Minister? Is the government? Is it a single minister? What are the procedural criteria? And there we already come into elements where we have certain restrictions. Some countries like Spain and France say it cannot be done twice in the same session or legislature. Others say that after a vote of non-confidence has been rejected, it cannot be repeated after 3 months, for example, in Estonia, after 6 months in Greece, after 9 months, sorry, I can't read this, and after 18 months in Papua New Guinea, for example. There are other rules, for example, that, like in Australia, non-confidence has been expressed twice. Very different mechanisms. Now, what are the limits of the votes? We'll look at that a little bit closer. How does a third party verify the vote? And what are the consequences of the vote of non-confidence? Now, if I come to the timing, I believe that timing is the most crucial in this clause, because the timing, we are looking at an incident where there's basically a standoff between different parliamentarians and loyalty is on the line. So it's a coup-like scenario which is constitutionally permitted. Usually there's an utter tension, and I believe that this tension needs to be resolved quickly. So I give the preference to the first and the second line within 48 hours, 2 to 3 days, at least 3 days. But the longer it takes, the more difficult it will be to effect a change of government. And I'm aware that, for example, in Papua New Guinea, there's a tradition to basically have a long break and rethink those matters. So every country has their own tradition, but it's important for every country to look at what works. I suggest that a short time frame is advisable. And in particular, here comes the element of the constructive vote of non-confidence, which means that you need to appoint another candidate at the same time. And that other candidate is, for example, Albania, Belgium, Germany, Nepal again, Poland have these mechanisms where you have a newly appointed government straight away. However, you will see from this research that we have done that there are very different scenarios again after a vote of non-confidence has been successful. So all of the mechanisms on the left can occur in different countries. Now, as you will see from my final slide, the vote of non-confidence may result in all three: in the appointment of a government by the head of state, in the direct election of a new government, or also in new elections. So this was my overview, and I'm excited to hear what my fellow panelists have to add. Thank you very much.
Thank you very much, Wolfgang. I think you've given us a very good start, a good background, and really going to the heart of this discourse today, the loss of majority in Parliament. What struck me was a very interesting view you expressed, that the provisions for a vote of no confidence should be part of the constitution of a country, and indeed just not part of it, but part of the basic structure of the Constitution. So it's not actually something that any successive government can tamper with. And that I think is important, and I think we'll see that in the presentations after this, where the executive chooses not to submit itself, or the government chooses under the control of the executive not to submit itself to a vote of no confidence. And because it's all left to basic principles and conventions, and it's open to many different variations of interpretations, and therefore, they effectively can prevent the vote being taken in Parliament. So that's a very good opening, Wolfgang. Thank you very much. We will move on now to our second speaker, Dr. Anna Gigits. Anna joined the Faculty of Law of the University of Hong Kong as a Global Academic Fellow in 2019. She researches in the field of comparative constitutional law with a particular focus on constitutional change and the role of judges and judiciaries. Anna's publications include analysis of constitutional law and constitution making in the Pacific Island states and Australia, as well as comparative work on aspects on federalism, courts, and parliaments. Anna.
Wonderful. Thank you so much, Stephen, and welcome and hello to everybody listening in. I want to begin by thanking the 4 law associations for convening such a wonderful series of events, and particularly to thank Dr. Gordon Hughes and the South Pacific Lawyers Association for inviting me to present on this panel. So in my presentation, I thought I would focus on just one aspect of the loss of majority in Parliament, and that's the no confidence vote. So Wolfgang's done a tremendous job of setting out some of the legal frameworks for a no confidence vote, and I don't want to duplicate his presentation. There will be a little bit of overlap, but I'll add some thoughts of my own about how constitutions, parliaments and courts all deal with no confidence votes. And this is based on a comparative study I did a few years ago, but with a focus on Pacific Island states. Pacific jurisdictions have, I think, really generated some really important case law in this area, and I hope it will be of interest across the Commonwealth. So just to reiterate, a no confidence vote is a vote taken by the Parliament to express a lack of confidence in the executive government. So a government that loses the confidence of the Parliament no longer has authority to govern. And aside from elections, no confidence votes are like the most important mechanism for ensuring the executive is accountable to the elected representatives of the people, the Parliament. But we know that confidence votes can be used for political purposes other than accountability. For example, the opposition might use one to criticise the government, even though they know it will fail. And prime ministers sometimes use confidence votes to kind of test the loyalty of their party members. No confidence votes can also be extremely disruptive. So once a motion of no confidence is put, the other business of Parliament stops until the question of confidence is decided. So repeated no confidence motions can be especially disruptive to the business of government. So this is really the tension I want to draw out. So you've got the stability and efficiency of government on the one hand, and the accountability of the executive to the Parliament on the other. And I think this is the tension that the constitutional rules and principles governing no confidence votes really has to try and balance. So originally in the United Kingdom, no confidence votes were governed by conventions. Now, however, it's fairly common for rules relating to no confidence votes to be set out in constitutions or in legislation or in the parliamentary standing orders. And rules and procedures, as Wolfgang has shown, deal with a range of different issues. And I don't want to repeat what he said, but I will highlight 4 because I think they show how the tension that I just described can be managed. So the first is the number of members of Parliament required to support a motion for a vote of no confidence. So before a vote can even be taken, there needs to first be a motion to put it on the agenda. And some constitutions set a minimum number of votes required for this preliminary step, ranging from 1/10 to 1/5, even 1/3 of the members of Parliament. And you can see how this helps to ensure that no confidence votes are only put where there's wide support and can't be used to disrupt government unnecessarily. A second issue is the timing of a no confidence vote, and Wolfgang talks about this. And he's shown how, you know, constitutions prescribe a minimum time and a maximum period of time between bringing a motion of no confidence and the vote itself. So the purpose of delaying the vote is to give MPs time to prepare and avoid really sudden changes of government. But the purposes of requiring that the vote be held within a certain period is, I think, one of them is to limit the opportunity for a government to unreasonably delay or try and kind of wriggle out or avoid a no confidence vote in order to stay in power. So third, in order to reduce political instability, some constitutions restrict no confidence votes. So one way to do this is to prohibit MPs bringing a second no confidence vote if they've previously brought one, or limit the number of no confidence resolutions a single MP may sign in any sittings. And another way, which was adopted in Papua New Guinea, is the use of grace periods, during which the Parliament is unable to bring any no confidence votes. So in 2012, the Constitution of Papua New Guinea was amended to provide that a no confidence vote may not be brought during the first 30 months after the appointment of the Prime Minister following elections. And this shielded the government from tests of confidence for 2.5 years, half its term. And the Supreme Court of PNG held that these amendments were unconstitutional because they undermined the system of parliamentary democracy established by the Constitution. And the court said, okay, a grace period of 18 months is okay, but no longer than that. So the purpose of these grace periods is to give a newly elected government time to settle in, develop its policies and legislative program. However, as the Papua New Guinea Supreme Court said, extended grace periods really restrict Parliament's ability to hold the executive to account, and they can entrench a government, and potentially a bad government, in power. Our final point of regulation relates to consequences, and I think Wolfgang's done a great job of talking about constructive no confidence votes, so I won't go into that. Only to note that when you've got constructive no confidence votes, you really kind of minimise creating the power vacuum. You know, it means that there's a clear successor to government and government business can continue relatively smoothly. So these are kinds of considerations that might be taken into account when designing rules around confidence votes. Another avenue to regulate no confidence votes is through the courts. So when no confidence votes are left to convention, conventions are not legally enforceable and courts generally won't get involved. But when rules and procedures for no confidence votes are written into the Constitution, the process is opened up to judicial review. And in the Pacific, we have seen courts in many jurisdictions deal with constitutional questions arising from no confidence votes. So you can see how this can place courts in quite a difficult position. On the one hand, the court is duty bound to uphold the rules set out in the Constitution. On the other hand, when the result of a legal decision can change the government, the court really risks being dragged into politics. And by and large, I think courts in the Pacific have been able to negotiate this tension, in part by being very explicitly clear that the court's role is to apply the law and leave the politics to others. So in Vanuatu, for example, the court is frequently approached to review no confidence votes. And in the course of doing so, it's really established a range of rules and precedents relating to prohibiting the Speaker from adjourning Parliament without allowing a debate on a confidence vote, or prohibiting the Speaker closing a session without allowing the Parliament to elect a new Prime Minister following a no confidence vote. So we see here that the Vanuatu courts have effectively set out a body of rules to guide the processes for no confidence votes, really filling in the gaps left by convention and written provisions in ways that then must be adhered to by the Parliament. I want to end briefly by noting that constitutional provisions and court decisions really can only go so far in fostering stability and accountability. So much depends on the nature of the party system, but also the quality of political leadership. So there have been occasions when judges in Papua New Guinea and Vanuatu, for example, have expressed this. They've noted the limits of the law in controlling the conduct of parliamentarians and really emphasised that personal ethics and fair parliamentary procedures are as important, if not more so, than strict rules. So I'll end it there and look forward to your questions and discussion. Thank you.
Thank you very much, Anna. That's really helpful. Again, you dealt with the grace period that sometimes is found in constitutions, otherwise is by convention. But I think that will be an interesting topic for discourse because it can so easily be open to abuse as well. With any grace period, it's just carte blanche for the government of the day to do as they like, and in that period, and then and hope to survive. Whilst otherwise, there could be a real check and balance as and when things happen. Even at the first 100 days, the so-called first 100 days, you can be called to account. So I think that's a very interesting concept, but I don't think it's widespread in the sense that I think many countries leave it just to conventions without articulating it. And I think there's something that we can take up later in the questions. Thank you again very much, Anna.
Thank you.
Our third speaker for this webinar is Mr. Shyam Divan. Shyam is the Vice President of Law Asia. He's a senior advocate who practices before the Supreme Court of India. His areas of practice cover most branches of civil litigation, including banking, securities law, arbitration, administrative law, and environmental law. Shyam is the co-author of Environmental Law and Policy in India, second edition, and has also most recently authored a chapter on public interest litigation in the Oxford Handbook of the Indian Constitution. India, of course, ladies and gentlemen, is no stranger to votes of no confidence. From the background research I've done, I think, and Shyam may correct me on this, there were at least, I think, 27 no confidence motions moved in the Lok Sabha so far, and I think 3 of them were successful. Shyam?
Thank you very much, Stephen. Good day to each one of the panelists as well as members of the audience. Thank you for this opportunity. Yes, I will look a little closely at the India experience in terms of no confidence motions. But I thought I should first and foremost give you a little background, very briefly. And then if there's a little time remaining, I'll just give you an introduction into a couple of current experiences and ongoing cases in the Supreme Court of India to give you a flavor of the contests which take place. So by way of background, number one, we have a written constitution at 146,385 words. It's the longest national constitution anywhere in the world. And my colleague Sugandha Yadav assures me that it's longer than the 5 longest Shakespeare plays. So it's quite a haul to sort of get through all of it. And unsurprisingly, because we have such a long constitution and we tend to engraft at least the essential rules in our constitution, there are provisions in the constitution post 1985 which deal specifically with at least one aspect of no confidence motions, which is a problem which you have across many jurisdictions where party affiliations are changed. So you have a situation where persons who are elected on a particular party, the expression which we use in India commonly is we defect. One of Stephen's mails to me described it as party hopping. Another common expression here in India is horse trading, because there is possibly some sort of an incentive given to legislators to shift their allegiance post-election, and that can result in a trigger to bring a government down. So there are certain rules which we've engrafted in the Constitution. The other point which I wanted to make is that we have a huge set of living experiences in terms of how to work a Westminster model and this whole issue of parliamentary democracy. Why? Because apart from our national legislature, India is a federation, and in our states plus New Delhi, which is not exactly a state, but it also enjoys a state legislature, we have representative governments which follow and which retain their confidence and continue in governance based upon the majority principle. So unsurprisingly, a large number of cases have worked themselves through the Indian court system, essentially through the High Courts and the Supreme Court of India. And I will draw attention to some of the important principles that have been laid down through this process. But before that, I should mention to you again that we have 8 national political parties. So independence was in 1947. The Constitution came in full force on 26th January 1950. So we worked the Constitution for 7 decades. And here, I think it's important to mention that perhaps before we embed and we imbibe values like constitutionalism, there's a very important value, which is at least to adhere to the Constitution, because you have several jurisdictions where you discard constitutions and you have new constitutions. So I think one place where we've been reasonably successful in India is at least to retain the Constitution. But one of the advantages in the Indian system in terms of constitutional amendments is that it's a relatively easy process. So we've had 104 constitutional amendments, but the core, the expression which Steve used a short while ago, which was basic structure, the basic structure of the Indian Constitution is retained because of a judicial doctrine. So despite the changes, certain core values, the republic nature, sovereignty, parliamentary democracy, certain key values in terms of fundamental rights are all embedded in the Constitution, and those cannot, according to our Supreme Court, be altered even by a constitutional amendment. Now, what's happened in terms of, so we have, perhaps I did mention, we have 8 national political parties, and in terms of the state, we have 53 recognized political parties. So each of these parties is sort of jockeying for position and power and trying to get into the majority to form governments across the states. So what has happened over a period of time is, and I'll mention just one feature in terms of an important constitutional background feature and then explain the principles derived. We have a very strong and powerful judicial review mechanism under the Indian Supreme Court, which the Indian Supreme Court has interpreted the Constitution to mean. And what this essentially means is that the Indian Supreme Court can and has, albeit very selectively, even struck down a constitutional amendment. So that's the power. Of course, it's a power which is used very, very sparingly, because if you use a power such as this frequently, then you're likely to have a tremendous political blowback. But what you have, so you have a great amount of political power, but then there's a competing principle. And the competing principle to judicial review is that we recognize that in the realm of the legislature, we, the courts, won't interfere, just as we do not want the legislature to interfere in our realm, which is the judicial sphere. Now, the first thing which Parliament tried was that when it brought in this anti-defection law through the Constitution, it engrafted a principle in the Constitution itself to say that court's jurisdiction is barred. But the Supreme Court, as the final interpreter of the Constitution, struck down that provision and said that judicial review, being basic structure, cannot be barred, and therefore retained the judicial review process. Thereafter, on a case-by-case basis, and this sort of feeds into some of the principles already laid out for you, are these. First, the court has said that, look, we are the primary protectors of the Constitution at the judicial level, and we will therefore ensure that constitutional and democratic values are protected to the hilt. First point. Second, it's therefore required over a period of time that a floor test is absolutely imperative. Because what was happening in India was that the floor test would be deferred and delayed. So the courts have now gone so far as to prescribe a time schedule for the floor test. The third point which the courts have brought forward is they've laid out a procedure, because sometimes you have situations where even before government formation, before the election of a speaker, So they have designated that you have to appoint a pro tem speaker for that session, have only one item on the agenda, which is the floor test for confidence or no confidence as the case may be, and thereafter adjourn and come forward. And they've also prescribed that there has to be a televised recording so that there is a certain degree of public confidence insofar as this process is concerned. Then they've gone a little further, and this is quite interesting. The person who has charge, as we know, is the speaker. What's been happening in India is that when you have a government which is in peril because certain legislators have changed their allegiance, they are liable to be disqualified. But the person who rules on this is the speaker. Now, we've had instances where the speaker has not ruled for months upon months upon months, and as a consequence, there's no disqualification. And if there's no disqualification, the government continues, despite in reality having lost that confidence. So the court has gone so far as to prescribe the period within which the speaker must take a call. But what we haven't done so far is the next step. What happens if the speaker of a legislative assembly or the state legislature does not follow the time schedule? Is he subject to power of contempt? You see, this is again where constitutional machineries break down. So there's a value in the constitution, and then there's a value to constitutionalism, which of course also involves restraint, obedience, and deference to other wings of government, including in a manner like this, the Supreme Court. And finally, one last principle, which is very interesting, is the Supreme Court's recommendation. The court, on the strength of its experience of working the Constitution for nearly 7 decades, finds that even though the speaker, of course, is above party allegiance, the expression used by the Supreme Court is that de jure or de facto, they have preferences towards a particular party. And in a situation such as that impartial duty of the speaker at a time like the no confidence motion is in peril. So the court has recommended to the legislature that please consider bringing in legislation by which you have someone who commands the respect of the public and is, evidently neutral, at least for the purposes of confidence and no confidence motions. We haven't gone there yet. It hasn't yet been adopted or translated in law, but this is an express recommendation by the Supreme Court of India. And I'll just end by giving you that one instance, which is actually a case pending in the Supreme Court, where the Speaker of the Goa Assembly, for example, of course, the pandemic intervened, but since January 2020, he hasn't taken a call on disqualifications. So you can imagine what is likely to happen if he takes a call, but it's sort of prolonged for more than 12 months. And that's a live case before the Supreme Court of India. Thank you very much.
Thank you very much, Sham. It is interesting again, this is another perspective to see the important role that a court plays in really giving value to the mandate of the people in the fact that they have casted votes and they've elected people into Parliament, and that vote is sacred. And of course, the judicial activism of the Indian Supreme Court is trailblazing. It's record-setting for many other judiciaries. And you mentioned something about party hopping laws. I think it is called party anti-defection laws in India. And I know because the Malaysian Constitution borrows heavily from the Indian Constitution. And like under the Indian Constitution, we have another competing right, which is the freedom of association. So that creates tension. On the one hand, you have laws that allow you to or may allow you to change parties. And then and that is supported by the fundamental right or liberty of association. But then you may have laws which actually prevent party hopping, and that runs contrary to the freedom of association. Again, I think that's a topic that we must explore in the question and answer session later. Our next speaker is John Mchenry Qc. Is unable to join us today in person. and I wish to tender his apologies. It's because of he's actually in a time zone where it's, I think, going to be very difficult for him to be with us live. But John has recorded his presentation. John was called at the Bar of England and Wales Inner Temple and took silk in 2016. Between 2016 and 2018, he was the Honorable Attorney General of Anguilla. John has appeared as counsel in many appellate courts, including the Privy Council, the UK Supreme Court, and the Eastern Caribbean Court of Appeal. We will now listen to the recording of John's presentation. Thank you.
I'm very pleased to be able to speak to you from the United Kingdom's perspective on hung parliaments and changes of government. I'm very sorry I can't join this fascinating discussion organised by Law Asia remotely and in real time, but the event will take place in the middle of the night where I am. But I'm very pleased to have been asked, and I send you all my best wishes as an executive committee member of the Commonwealth Lawyers Association. And I know my colleague Stephen is with you all moderating this panel, so there is good CLA representation. I am going to speak for no more than 10 minutes because the question of change of government when there's no majority in the context of what we call in the United Kingdom a hung parliament is an issue more of constitutional and political convention than it is a question of straightforward constitutional law. It is probably a mistake, it's not probably, it is a mistake to think that the United Kingdom doesn't have a constitution. Of course it does. There is a series of laws, conventions, rules and arrangements that regulate changes of government and the interrelationship between the executive, parliament, the courts and other bodies. Challenge that we have in identifying any clear rules-based system for changes in government is what is it we're looking at and where are we looking? And that can sometimes be quite confusing. It's important to bear in mind that I've been asked to speak about the United Kingdom, and to some extent the changes of government based on voting for what I'm going to call the Westminster Parliament are really the most complex, because Westminster is still ruled largely by way of conventions and historical approaches, whereas the devolved parliaments have a more clearly codified approach. So, for example, I will briefly touch upon the situation in Scotland, where there is a parliament. There is also, of course, an assembly in Wales and an assembly in Northern Ireland. We also, of course, have local government and local councils, and I'm not, I'm afraid, going to be able to deal with those in this short discussion. I will look briefly at the situation in what I'm going to call Westminster before turning to look very more briefly still the situation in Holyrood, which is the name for the Scottish Parliament. The issue, the political issue of change of government has been one that has rarely troubled the British body politic, but has troubled it more in recent years than it has for much of the time since the Second World War. For large swathes of time, post-war British government has really been based on clear majority government. That was largely the situation after the war, with first a period of Labour government, and then a long period of Conservative government from Churchill up to Douglas Hume, and then back to Harold Wilson's Labour administration. We did see in 1974 an issue regarding the formation of a minority government, which eventually took place under Harold Wilson. Then we went back to a Labour administration until 1979, and then for a very long period, from 1979 until 1997, we had majority Conservative administration, first under Margaret Thatcher and then John Major. And then we had another very long period of majority government under the Labour Party, first with Tony Blair and then with Gordon Brown, which ended in 2010. The 2010 election was a very interesting one because the Conservative Party took over from the Labour Party, but only by way of forming a coalition government with the Liberal Democrats. Now, the circumstances in which that took place were not particularly clear. Gordon Brown remained Prime Minister, and I think it was one of the political challenges for him that he was described as being a squatter in Parliament at number 10, a description which I think hurt. The Conservative leader, David Cameron, took the view that he should, as the leader of the largest party, have the best placed opportunity to negotiate to form a coalition government. And he successfully did that with the leader of the Liberal Democrats, Nick Clegg, who became Deputy Prime Minister. We then had a fixed term Parliament Act implemented, which changed the political scenario because Prime Ministers lost the discretion when to call a general election. And in exactly 5 years later, under the fixed term Parliament, there was a further election, which David Cameron won. And then in June 2017, there was a further general election because of the ramifications of Brexit. And Theresa May lost the Conservative majority in June 2017 and then formed a minority government, but with the support of a party from Northern Ireland. And then in December 2019, under the new leader of the Conservative Party and Prime Minister, Boris Johnson, we returned to clear majority government. So in those rare examples, 2010, 2017 and 1974, what really determined what should happen? Well, in Westminster, there is no clear statutory framework. There are a series of rules or what are called formature of selections of government. The first straightforward principle is the majority principle. The party that commands a Commons majority names the formature, the party that goes forward to form the government. But there's also a further convention which is called the continuation rule. And the continuation rule really says it's for the incumbent Prime Minister to make the first attempt to form the government. And of course, under the law of the United Kingdom, under English law or Scots law, the Prime Minister remains the Prime Minister until the new government has formed. There is the gravitational principle, which is that the party that's most likely to form the government should take the lead in determining who leads that government. And then there are a number of other ways in which you can gauge which party should take the lead in determining who the Prime Minister should be. There is the plurality principle, which party commands the largest number of seats, and that's what happened under David Cameron in 2010. And there is the plebiscitary principle, the party that commands the largest vote can take the lead in forming the government. That doesn't often happen in the UK. What we have seen is the party with the largest seat share doing so, or the Prime Minister of the day who's lost his majority being able to try. So those are the two real bases. But what we certainly try to do as a matter of practice in the United Kingdom is ensure Her Majesty the Queen remains above it seems to make any political decisions. It would be wrong for the monarch to be involved as a matter of constitutional law in determining who leads. But of course, it is a matter of convention and constitutional principle that Her Majesty the Queen invites a leader to form a government and that leader to become Prime Minister. And therefore, in our rules which set out how the cabinet functions, the Queen may well invite the leader of the party that remains in power or the leader of the party with the largest number of seats in the House of Commons. Those are the two key principles. If there's a dispute between these two, and if there's likely to be a difference in outcome, then there must be very clear advice given to Her Majesty so that it's clear she's not in a position of being embarrassed by having to choose. So that really is the constitutional position when there is a hung parliament in Westminster. If I can turn very briefly to Scotland, we have a different system because the Scottish Parliament is a creature of statute. And it is set out, regulated, provided its constitutional basis in legislation called the Scotland Act 1998. Section 46 of the Scotland Act provides that after a general election, or following the resignation of the First Minister, that being the term for the Prime Minister, the First Minister, the Parliament must nominate one of its members as First Minister, but must do so within 28 days. Unlike Westminster, there is a limit to time. The presiding officer, who is the equivalent of the Speaker, must then recommend that person for appointment to the Queen. And the standing orders provide for the election of the First Minister after members have been sworn in on a date to be decided. And what happens then is that each party puts forward a candidate for First Minister in the Parliament, and the candidates are then voted on, and the candidate at each round with the least number of votes is then voted out. This is what happened in 2007. On the election in Scotland in 2007 led to a hung parliament. Labour lost control of the parliament. The SNP had 47 seats, Labour 46, the Conservatives 17, and other parties less. Alex Salmond was put forward as First Minister by the SNP, Jack McConnell by Labour. Voting took place, and at the end of the day, Alex Salmond had the most number of votes, so became First Minister, all of which took place within 28 days. That seems to me to be a much neater and cleaner situation and provides greater constitutional clarity. And there is, among some constitutional lawyers, a discussion about whether a similar procedure, such as set out in the Scotland Act, should apply to Westminster. Personally, I think that's unlikely because Westminster is an institution imbued with history and traditions. And the unwritten but carefully crafted constitution of the United Kingdom does provide for compromises and outcomes that can sometimes be more beneficial than a rigidly set out statutory regime. And of course, constitutional principles should really be above mere statutes. I hope this discussion is interesting for your debate. I repeat my apologies that I cannot be with you all, and I wish you a very successful Law Asia event. Thank you very much.
I'd like to thank John for having his message recorded for us. And he has, of course, again raised certain issues perhaps that were not really covered in the first three presentations. As we can see that in the UK, the system is still largely governed by conventions, somewhat reduced to rules, and I think he mentioned principles, which may be some form of guidance. But I think the interesting question would be post the Miller and Cherry case, whether these conventions and rules and principles that are applied in Westminster, whether they are justiciable. And whether these would be, that in that sense, be subject to judicial review. John also mentioned the specter of minority governments. I think we'll hear about that a bit later, and how minority governments have functioned in the UK. Not again, I think, a norm that we see across the jurisdictions here, but certainly I think an experience that we can learn from. We move on to our next speaker, who is Mr. Saroj Ginri. Saroj practices at the Supreme Court of Nepal and is a former treasurer of the Supreme Court Bar Association. His areas of practice include constitutional law, human rights, foreign investment, and he has experience in advising in complex commercial transactions. Saroj was one of the lawyers who appeared recently in a case involving the dissolution of the House of Representatives of Nepal, and I believe the Supreme Court, or is it the Constitutional Bench of the Supreme Court of Nepal, handed down its decision on the 23rd of February, just 2 days ago. I'm sure Saroj will deal with that recent decision, which is topical for the webinar that we have today. Saroj.
Thank you, Stephen, and thank you to all the speakers and the attendees in this esteemed webinar. Thanks to LAWASIA, Commonwealth Lawyers Associations, the Council of Australia, South Pacific Lawyers Association for inviting me to speak on these very contemporary issues that we have recently witnessed, and the Supreme Court of Nepal has given a verdict on the dissolution of the parliament. Without taking any further time into this one, I'll try to go into the situations that we have surfaced recently. So I'll be specifically focusing on the recent dissolution of the parliament and the Supreme Court's verdict over the reinstatement of parliament in our country. The political climate of Nepal over the past few months was quite unstable. The government was formed by the merger of two major political parties as the Nepal Communist Party. The party in the government also nearly a two-thirds majority. However, due to the intra-party feud among top leaders of the ruling party and their constant battle to hold the power between them, we faced the unstable political horizon, which carried a constitutional crisis in our context. The ruling party's conflicts led to the situations that the Prime Minister sensed the possibility of no confidence motion that may be brought against him in the parliament, and upon sensing the loss of the majority in both party and within the party and the house, the Prime Minister finally dissolved the parliament and avoided the options for the formation of the new government. So consequently, on the recommendation of the cabinet, the Right Honorable President Bidya Bunari, she ratified the proposal of the cabinet to dissolve the parliament. And on her statement, she clearly mentioned that the parliament is dissolved based on the fundamental principle of parliamentary system, based on our own practices that we did in the past and the practices of the countries having the parliamentary system, and for the fresh mandate of the people. However, this dissolution was much in controversy. We had a constitution in the year 1991 that gives the prerogative to the Prime Minister to recommend for the dissolution of the parliament to His Majesty. And we had a few dissolutions before, which was ratified. However, this time, the constitutions, understanding the past events and the political instability that was surfaced in Nepalese politics, the constitution has no clear provision that allows the Prime Minister to dissolve the parliament. However, the Prime Minister, Right Honorable K.P. Sharma Oli, while he recommended for the dissolution of the parliament, he stated a few important reasons that made him to dissolve the parliament. He mentions that the government did not receive any support within the party, and the intra-party dispute is allowed to carry development works. The unfair political settings and plots that were framed against him by the senior leaders of his own ruling party create an unfavorable conditions environment for the government to function. The Prime Minister also claimed that the several attempts were made to assassinate his political career, and thus the dissolution was no other options. In his reason for the dissolutions, he also mentioned that they require the fresh mandate from the people, and the Prime Minister thus retains the prerogative power to dissolve the parliament. He mentioned that there was no possibility of formation of the alternative government within the scope of the constitutions. The government was formed by the two-thirds majority of the ruling party, and there was no legality of facing no confidence filed by the members of his own party. That was the reasons that the Prime Minister gave to us on the mentioning the grounds for the dissolutions. And he also mentioned that the dissolutions was absolutely a political issue and thus falls beyond the scope of the judicial scrutiny. So, however, we consider that the dissolution was absolutely a constitutional coup made by the Prime Minister. So PIL was filed against this dissolution, and the 13 writ petitions were filed against these dissolutions, and it was heard at the Supreme Court, at the Constitutional Bench of the Supreme Court. And I happen to be one of the leading lawyer on this case against the dissolutions. So the case was heard by the 5 justices of the Supreme Court Constitutional Bench and heard for the nearly 2 months ongoing. So at the beginning I was confused, and I was also quite in dilemma that how should I deal on that issues in this webinar. But luckily, the Supreme Court came with the verdict, so it made me easier to talk on these issues today, on this which is not the sub judice now. So finally, on February 23rd, day before yesterday, the Supreme Court gave a verdict with few important reasons that the Supreme Court pronounced, where the Supreme Court says that the Supreme Court cannot go for the judicial hands-off just because the issue is has a political importance or is related to the political activities. In the verdict, the Supreme Court said that the dissolution of the Parliament has a serious constitutional issue, and the Constitutional Bench has the constitutional obligations to address on such issues. Because the question that came from the opponent, from the Prime Minister, was that it goes beyond the scope of the judicial scrutiny. Libya's parliament system has written its own uniqueness. Then the customary element that was there in the order constitution, which allows the Prime Minister to dissolve the Parliament. The notions of the parliamentary system are also oriented to discourage orderly dissolutions of the Parliament and has introduced the concept of responsible limited government. The court took the note that the order of dissolutions has created a political instability in the Nepal. And the court closely looked into the lexicographer of the constitutions that was promulgated by the Constituent Assembly, that the dissolution is not explicit within the explicit authority of the Prime Minister. Hence, despite of taking alternate recourses before the dissolutions that was announced by the Prime Minister, the court says that Parliament cannot be dissolved on personal interest and whims of the Prime Minister. The court further said that the Prime Minister has no exclusive prerogative to dissolve the Parliament before confirming that there is still the possibility of forming the alternative government. So the Prime Minister has the obligation, constitutional obligations, to see whether there is opportunity for the alternative government to be formed or not. Hence, the Supreme Court issued a writ of certiorari declaring the dissolutions as unconstitutional and has called for the reinstatement of Parliament within 13 days of the order. So the 3 days has already lapsed. The Supreme Court, they say we have taken this one as one of the landmark judgment after 2 months, nearly 2 months hearing into this one, and Supreme Court taken into consideration all past event, and thus has pronounced that the Parliament should be reinstated. And Supreme Court took into consideration of the constitutional principles. However, the Supreme Court was alienated from the constitutional conventions of dissolutions that we did in the past based on the previous constitutions. And the Supreme Court clearly says that the dissolutions is against the public policy, and this reinstatement will ensure the political stability in the country. So we are waiting for the Parliament to be reinstated. The next move would be the Prime Minister to call for the reconvening of the Parliament. We are waiting if the Prime Minister resigns. If the Prime Minister resigns, then there will be a new request for the formation of the new government. But yesterday we heard the speech of the Prime Minister, and it seems that it appears to us that Prime Minister is not going to resign. So if he doesn't resign, then there will be the Prime Minister has to face the vote of no confidence in the Parliament. it depends on the constitutional morality of the Prime Minister. If the Prime Minister will likely to face the no confidence motion in the Parliament once the Parliament is convened, and that is what the constitutional mandate is. That so if his confidence is not met, the Parliament will give a new government, and so there is no alternative options or justifiable excuse to the Prime Minister to defer the vote of no confidence now. The parliamentary motion stands on primacy after the reconvening of the Parliament. The Prime Minister's prerogative to dissolve the Parliament without confirming the constitutional steps that the new Constitution of 2015 has defined or finding the alternative government has been struck down by the Supreme Court. And though the Parliament is reinstated, but still we can see that there is another round of political instability. A new power equation is going to be there. So we are looking for the best of us and for the development of the new constitutional values, constitutional interpretations, and best practices of parliamentary system that we have seen in the Westminster movement. Thanks.
Thank you. Thank you, Saurabh.
Clear to
Yes, thank you very much. That's a very far-reaching decision of your constitutional bench. In many of our jurisdictions, one speaks of the discretion that the Prime Minister has and the prerogative of the constitutional monarch to dissolve Parliament. But your constitutional bench has actually laid down rules to say that is still not inviolate, and that you could actually ask or have rules put in place as to how that power can be exercised. In other words, it cannot be exercised for personal reasons. It cannot certainly be exercised at the drop of the hat. So I think that is a very important decision, which we hope that we can discuss later in the question and answer. We'll move on now to our last speaker, last but not least, Deborah Angus. Deborah is a barrister from Lambton Chambers, Wellington, New Zealand. Deborah has about 20 years experience working at the heart of parliamentary democracies, specializing in public law and democratic governance. She's an expert advisor on public, constitutional, electoral, and parliamentary law and procedure, public finance management and public sector oversight, governance and funding. She has a deep understanding of parliamentary and public sector processes and works as a trusted advisor to clients, officials, and international organizations. And on behalf of all four organizations, I want to thank Deborah. She actually had another speaking engagement that clashed with this, and she very kindly made arrangements to finish with that and rush onto our screen and carry on with this. Deborah.
Thank you very much, Kia ora, and greetings from New Zealand. I seem to today be the wrap-up speaker for two events, and I'd like to thank you all, and I'd also like to thank the New Zealand Law Society for nominating me for the panel. I'm going to discuss some overarching principles about quantity, clarity, and transparency that's used to guide government formation in New Zealand, and then touch on some measures that have been used in the Pacific region to constrain instability, including anti-party hopping legislation and procedural limitations on moving votes of no confidence. New Zealand, very unusually, does not have a written constitution and relies on a set of instruments. So it's a bit like the position that was described in the United Kingdom. But in 1996, New Zealand changed from a first-past-the-post electoral system to a system called mixed member proportional. And since the introduction of this system, coalition and minority governments have been the norm. Only in the most recent election last year, that produced one party with sufficient majority to govern alone. And even then, the Labour Party has chosen to enter into a support agreement with the Green Party, and it's known as the Labour government with support from the Green Party. So the responsibility for the choice of government, for the formation of government and the choice of Prime Minister falls directly actually on political parties to work out the accommodation. For example, is it going to be a coalition, a confidence and supply or support agreement? And as a result, strong conventions and principles have developed around the formation of government in New Zealand. Now, by convention, New Zealand's head of state, who is the Governor-General, appoints as Prime Minister the person who commands the confidence of the House of Representatives. So after an election, the conventional role of the Governor-General is to ascertain where the confidence of the House lies so the government can be appointed, and constitutional conventions have developed around this. The Governor-General is required to act on the outcome of the electoral process and subsequent discussions of the political parties, and to act on the outcome of the political process, which will identify who will lead the government as Prime Minister. So this has led to the development of these two principles, which are expressed quite clearly as being quantity and clarity, the confidence in the House, expressed in clear public statements. So if we turn first to quantity, the formation of the government depends on one or more parties being able to show that they are able to command a majority of support in the House. In 2017, a government was formed by a Labour New Zealand First coalition with a confidence and supply agreement from the Green Party. Now, this for the first time, the leader of the party with the single largest share of the votes was not able to secure a majority. The Labour Party had a smaller number of votes, but it formed a government with two other parties because it was able to demonstrate what is called quantity. Moving next to clarity, it's not enough for a party or a grouping simply to have the numbers. They must publicly communicate the results of their negotiations in clear, unambiguous statements, oral or written. While oral statements can be made, a written statement sets out greater certainty in terms of transparency. So over time, these processes have developed and they've become very transparent. For example, the high-level principles are recorded in the Cabinet Manual and published on the website of the Department of Prime Ministers and Cabinet. Several Governor-Generals have also made public statements about the process that they would follow, and they've published these. Coalition and confidence and supply and support agreements are all publicly available on various websites. So it's very clear what matters command or involve the confidence. So while the politics of government formation takes place behind closed doors, the process and results are transparently communicated. So the mechanics of government formation in New Zealand may be quite uncomfortable during this time, but there is clarity about how to go about it. You can look on the website under a heading called Formation of Government. So while minority governments have become the norm in New Zealand under our electoral system, the concept of confidence has also been sharpened in terms of what does this mean. Confidence of the House is tested at various times. For example, there are a number of sort of set piece debates and issues. These would involve a vote of confidence and the loss around them, or a loss in terms of an amendment that was made would actually result in the government not commanding the confidence of the House. So this involves a address and reply debate, which is held at the opening of the new Parliament, the giving of the Prime Minister's statement every year at the beginning, the passing of budget or other measures, and also matters which the government treats as raising matters of confidence, and some of these are articulated in the confidence and supply agreements. Now, this is a somewhat negative and circular concept in terms of confidence, and Wolfgang earlier covered many of the options about what would happen if there's a defeat or no confidence. So I'm not going to repeat those. But in New Zealand, what has happened is rather than having or waiting for a vote of no confidence, the government has actually acted first and sought out a vote of confidence. So, for example, in 1998, when a national and New Zealand First coalition collapsed, the Prime Minister, the then Prime Minister, who'd actually defeated or replaced a former Prime Minister in a leadership coup, acknowledged that there was an obligation to test the confidence of the House, and she or the government put forward a vote of confidence in the new government about 1 week after the government was sworn in. Now, this is not in any particular rule. There's no particular procedure in New Zealand standing orders or nothing in any document that requires it, but it's developed around a convention. So not every loss of votes in the House in New Zealand will require a vote of confidence or will require the government to resign. New Zealand's and the government's been defeated on a number of pieces of legislation, but they didn't involve the loss of confidence. Even this concept of a vote of confidence can bring its challenges. Recently, and looking in the wider Pacific region in the Cook Islands, the former Prime Minister, the Honourable Mchenry Qc, resigned as a Prime Minister, but remained as a Member of Parliament. Now, the former Deputy Prime Minister, the Honourable Mark Brown, was the Cook Islands Party's choice for Prime Minister, and a motion of confidence was lodged in order to test the confidence of the House. But in the end, the motion did not proceed. The opposition had a walkout, and the Queen's representatives was left to be satisfied in other ways about the formation of government in terms of both quantity and clarity. If you look at it, overall the numbers had not changed, and the existing arrangements with some independent members remained in place. If I can just move quickly now to look at measures to strengthen government formation, because that's really the counterpoint to instability, is how do you actually make sure that there are strong measures around stability. Floor crossing tactics have had a considerable impact on government formation and how this works, particularly in the Pacific region. The fluidity of parties tends to lead to instability, leading into no confidence votes and allegiance shifts. And as a result, governments can become preoccupied with maintaining loyalties. There's actually a reluctance in some cases to call Parliament at all in case there's a vote of no confidence. And then this leads to poor performance generally of legislatures, a low number of sitting days, lack of oversight by parliamentary committees, and the hasty passage of legislation and budgets. So responses to these problems have looked at bringing on stability, for example, by strengthening parties through party registration, discouragement of independent MPs or discouragement of parties, and restraints on party hopping, automatic triggering of dissolution, the power of constituencies to recall Parliament or members, and the enlargement of cabinet size to accommodate particular interests. The development of electoral integrity legislation, and this is called anti-party hopping, or in New Zealand it's referred to as waka jumping, which is the waka canoe jumping, has actually received a lot of discussion, and I think it's probably a worthy topic all of its own. New Zealand has had this legislation on a number of times. It's tended to have a sunsetting clause, or it's been repealed and it's come in and gone out in relation to various confidence and coalition supply agreements. The Cook Islands also has this type of legislation, and a court challenge several years ago sought a declaration that a member's seat had become vacant as a result of the operation of the legislation, where a member moved from the opposition to become a member of the executive. Now, there was a challenge to the constitutionality of that legislation, interestingly enough, brought by the Crown, and the court rejected the claim that the particular actions in this place, which was really in this situation, which related to the passing of the budget, was sufficient to trigger the vacation of the seat, because it couldn't be shown that the member had failed to support the majority of the parliamentary parties of the political party for which that member was elected. whatever the arguments to and for such measures, the New Zealand experience has been that when this type of legislation has been in place, no member has resigned from their party, causing the election to be triggered. Finally, I'm just going to touch on some of these procedural restrictions on votes of no confidence. So some states have restrictions on when and how a vote of no confidence may be moved. And so, for example, in Vanuatu, there are restrictions around the dissolution of Parliament and basically around the calling of an extraordinary session where a vote of no confidence might be held. What has tended to happen is that support for this is dissipated away. So in the recent change that's been made to Vanuatu standing orders, the calling of an extraordinary session needs to be signed by a majority of members at the same time in the parliamentary precincts, in the presence of the clerk or the speaker. And at least a certain amount of notice must be given, and the notice of motion of no confidence must be dealt with immediately. It is the first item of business, which means that once all of those steps have been through, the vote of no confidence will be held. In Tonga, under the Constitution, a certain period of notice must be given for a notice of motion of no confidence in the Prime Minister. It cannot be moved within 18 months of the holding of a general election, or within 6 months of the date of election. And there's a very prescribed procedure under the Constitution under what might happen if the Legislative Assembly passes a vote of no confidence. The rules of procedure in Tonga now set out very detailed procedural requirements around the calling of the motion, the debating of it, what must be dealt with, following a very long and protracted debate and a real lack of clarity about what actually happens when a motion of no confidence is debated. And when the first motion was debated after constitutional reforms in 2011. So these principles that I've talked about, these principles of quantity, clarity, and transparency are really, I think, essential when you think about how do you go about formation of government, because they actually apply each time a government is formed. And I hope that my very brief skipping over anti-party hopping legislation and examples of some procedural limitations will stimulate some discussion later on. Thank you, Stephen.
Thank you very much, Deborah. If I may say so, you've actually brought together the different strands of issues and the matters that we have discussed very well, in like a summing up actually of everything that we've been discussing with the other panelists. We have a few minutes for question and answer, and we have received some questions in advance from our participants. I'm just trying to wrap them up so that we can take them under a couple of broad heads as opposed to dealing with them individually, if that's all right with you. And I think the first one I want to raise is really what Deborah mentioned towards the tail end of her presentation, the so-called anti-hopping laws, or the the skip jumper that Deborah mentioned just now, or the anti-defection laws. And some countries have it, and then there's a question of whether or not, as I said, whether or not it's contrary to the freedom of association, whether that's entrenched in a written constitution, or whether that's part of a principle that is applied in the jurisdiction. Can I have your views as to the sustainability of these laws, the need and the sustainability of these laws, broadly called the anti-hopping or anti-defection laws? Wolfgang.
Thank you very much, Stephen. With your permission, I'd like to also briefly comment on my fellow speakers. To Sham, you said that India uphold the constitutions. I actually think the constitutions around the world are the unsung heroes of the 21st century, because they basically protected us from rising nationalism and populism around the world. So Raj, very impressive. We are looking for you tendering your application, your candidacy for the Speaker of the Nepalese Parliament. Deborah, I think the clarity would be wonderful to achieve across many nations. I think this is what is missing. And last not least to Anna, and I think Anna touched on the point that you made, Stephen, in terms of moral and ethics, because I think this party hopping has to do a lot with how we treat opposition. So I think there's quite a difference in a lot of the civil law jurisdictions which are consensus built, which have a lot of coalitions and which have intertwined systems of giving rights to one each other. So for example, proportional representation on committees, or for example, also the way that constitutional judges are appointed. I mean, we all know the awful example that the US has been presenting to us over the past years. In some jurisdictions, you need a 2/3 majority in parliament to appoint a constitutional judge. And that then requires the cooperation of the ruling party and the opposition. And I think if you strengthen those rights of the opposition, you will have less party hopping, because I'm a great fan of what you, Stephen, mentioned, which is the freedom of association. The deputies we elect, they are subject to their own views. That is their mandate. It's not the mandate to follow the party or to follow a leader. Their own conscience is important, and that then of course is important for building the morals and the ethics in a country. Thank you.
Thank you, Wolfgang. Anna?
Sorry. Yeah. No. I think I agree. I think that there is a case in Papua New Guinea where these laws came before the court, and they said exactly what you in the Malaysian context have said. They struck them down as unconstitutional on the basis that they restricted the rights of parliamentarians to represent their people and freedom of association. I would just point out that anti-party hopping laws can perform different functions depending on what your electoral system is. I don't want to get too complicated, but when you have a proportional system and I vote for a person based on the party that they're in, you can see how an anti-party hopping law seems more sensible, because I voted for you as part of that party. You shouldn't be able to skip out of that party. Whereas in systems where you vote for a single member and then it's up to them to form a party and decide which party they're in, anti-party hopping laws can be a little bit more difficult to justify. And I'm worried about some countries. I have Samoa in mind at the moment, where you have an incredible majority in parliament. The one party holds most of the seats, and there's anti-party hopping laws in Samoa, and there's potential for them to be abused and prevent, really maintain party control where there is not really a need to do so based on the stability rationale.
Thank you very much, Anna. Sham?
Yeah, I'll just come in here. I'll make 2, maybe 3 points. The first point is these anti-hopping laws, I think, respond in time to a certain level of constitutional development. So I think in many societies which have established and very strong roots in constitutionalism, this may not be so much of an issue. And you have the competing rights of freedom of association. In India, it was tested in the context of freedom of speech, etc. So that that's the contestation which I see changing over a period of time. When I look back at the India experience, I think we definitely require an anti-defection law. And I'll just share with you a couple of images. The first is when we have situations of a hung assembly, it's very, or someone, hopping, or a set of elected representatives hopping from one party to the other. You have huge media coverage of the remaining flock of legislators being put on buses and airplanes and being secreted away into some sort of a resort, their cell phones being confiscated so as to prevent parlays and what I described as horse trading. So you have a system where the political parties themselves at a certain level are not adequately trusting their members because they fear that they may cross over because of some sort of an inducement. The inducement could be monetary, but it needn't be monetary. It could be an assurance of, a ministerial berth or who knows what. So for all these reasons, I think at least this is the response has to be local. The stage at which we are in the India context, I think instead of having these electors being carted away in buses, and this is despite having a law, I think freedom of speech and association would perhaps, in a court's view, be placed at a subordinate level, because otherwise the whole foundation of an elected government gets completely undermined and decimated. So that's my response.
Thank you very much, Shyam. Saroj? You're muted, Saroj. You're muted. Can you unmute? Yes.
Thanks.
Yes.
Thanks. We do have the anti-defection law, and in the past we have experienced this kind of defections in our political history, and we are closely observing the possibility of defections in the new course of the parliamentary affairs that's going to happen very soon. So we don't have much developed jurisprudence on this one, but definitely in our parliamentary system, this has become one of the pertinent issues of the anti-defections. So I hope the new recourse that upon the reconvening of the parliament, the gaming of the defection come within us, and we can see how the defection law would be able to address on those issues and other further development with this one. So I think for now we don't have much issues to elaborate on.
Thank you, Saroj. And Deborah.
I think that the comment made by previous panelists that where you have a proportional system, there's actually quite a strong argument around having a or what's called in New Zealand as electoral integrity legislation. So the people who, particularly who are on a list, you can see people might have voted for the party because of who was on the list. And the experience really is that members who go off and join other parties will distort, if that happens, it distorts the proportionality of the parties in Parliament. And so that's the direct link in. That said, there's been a lot of debate about this, and a lot of members, because it applies, New Zealand has a mixed member system, so some members are actually constituency members, and certainly there are arguments to be made in terms of freedom of association and independence and around being able to have their own views. But the experience has been that when this legislation has been in place, there has not been a call on it in terms of having disputes around it. And interestingly, that in that Cook Islands legislation, that when it was challenged, the Cook Islands High Court sits with 3 New Zealand High Court judges, and the arguments, which I said were interestingly raised by the Crown as to the constitutionality, so by the Attorney General, basically trying to argue around whether or not it was constitutional. The court found it was in accordance with the Constitution. So obviously, you know, there are different experiences in different jurisdictions. Thank you.
Thank you very much, Deborah, and may I thank all our panelists for your contributions to this webinar today. We've come to the end of the webinar. We're out of time, and the number of questions actually runs to about 4 pages like this. Those are the questions. That tells you, you know, the width and the breadth of this topic, and it gives rise to so many other subtopics. I think it could have many other webinars on this. But if you allow me, I think 1 or 2 things that I think we can take away from this. One is, I think, when we speak about loss of majority and the need for whether loss of majority and the incidence of a no confidence vote, I think the majority view here would be that, you know, it should be properly regulated, or there should be clear rules about it. And I think leaving it to conventions may not be the proper way going forward, given that it can lead or give rise to abuses by the government that's in power. We heard a very interesting recent example of the use of the power of dissolution by the Prime Minister, and how the courts have now taken the view, just as they did in the Miller and Cherry case, that it cannot be the sole preserve of the executive on these matters, and can be justiciable, but along very strict principles and lines. And then finally, on the anti-hopping laws, I think the majority view here is also that despite concerns about freedom of association, I think there's need for those laws, and for those laws to be in place to protect the value of the vote that has been cast at the elections. And when that vote no longer is sustainable in Parliament, then perhaps the right thing to do is to submit to fresh elections and to a fresh mandate. That, I think, would be a broad summary of everything that we've discussed in this very broad subject and topic. Thank you again, panelists, for your wonderful presentations. I would like to thank the participants who have been with us. And I hope that you've enjoyed the presentations and there's been good takeaway from it. I mean, I also say that the third segment, the third webinar that comes after this is titled Constitutional Breakdowns, Coups, Crises and Disruptions, Experiences from the Commonwealth. And that's on the 4th of March, next Thursday. Thank you, and I wish you all a good day, good evening, good afternoon, or good night. Bye-bye.
Thank you very much, Stephen. Thank you.
Thanks, Stephen.